We now turn to the fourth case on this morning's docket. That is case number 104504, State of Kansas Appellee v. James Arthur Qualls, Appellant.
Please, Court. My name is Charles Scott. I represent the appellant, James Arthur Qualls. And, Your Honor, at the outset, could I reserve 3 minutes for rebuttal?
3 minutes is granted.
And in my argument, I'm going to address the one issue of whether the trial court erred in refusing to give an instruction on voluntary manslaughter in the trial for the appellant. I'll rely upon my arguments in the brief on the issue of the refusal to give the instruction for self-defense and whether there was sufficient evidence for premeditation, unless the court has some questions on those two issues. The law that is applicable to this case is clear and straightforward, that a criminal defendant has both a constitutional and a statutory right to present the theory of his defense in the case, and is entitled to an instruction on that defense if there is evidence to support that defense. And so the only issue before this court is whether there was evidence in the trial court, in the record, which supports the defendant's request for the instruction of voluntary manslaughter. I know we're not supposed to, generally, the court is familiar with the facts, and we're not to go into great depth and discussion about the facts, but as far as I can see, that's the only thing to discuss before this court is the facts, because the law is pretty clear.
Let me ask you this before we get there, because I think there are 2 points we have to look at. One's whether the instruction was appropriate. But if we find that it should have been given, what's the standard of review? What's for the harmless error analysis? We have to decide whether the failure to give was harmless error. Is it a constitutional standard? Is it a statutory standard? Is it both?
Well, the case law that I have cited that says it's refusal to give instruction for a lesser included offense is clear error, and which means it's prejudicial error. In fact, refusing to give that instruction basically denied him the opportunity to present the theory of his case, of the defendant's case. So the defendant's request for the instruction of voluntary manslaughter was based upon the fact that he claimed that he had a honest, perhaps unreasonable belief that he was in imminent danger of being shot by the victim in this case, James Robert Breyer. In other words, the defendant shot Mr. Breyer before he could shoot him. That was his defense. And the evidence to support that claim was certainly the defendant's testimony. As the court is aware, the defendant was briefly the defendant, Mr. Qualls, and Mr. Breyer had an argument, and in fact got into a fisticuff. The fight was broken up by a security guard, and after the fight was broken up, Mr. Qualls and his party proceeded to leave the bar, walked toward the door to leave the bar. Mr. Qualls, as he was walking, Mr. Qualls heard his wife yell his name, James, which alerted him to turn around. And as he turned around, he saw the victim walking toward him with his hands in his waist. And Mr. Qualls perceived that to be that the victim was reaching in his waist to grab a gun. Again, Mr. Qualls testified that he did not per se see a gun, but he thought that he was reaching for a gun. Now, it's a question for the jury, I would submit, whether that was reasonable for him to make that assumption.
Well, that's not really the question whether it was reasonable for him to
Right.
believe he needed to use deadly force
Yeah.
with regard to voluntary manslaughter.
That's true.
You're basing that on an imperfect self-defense.
Right, imperfect,
So
right.
the question is the subjective thought, or is his subjective belief that he needed to defend himself sufficient to give rise to the voluntary manslaughter instruction based on imperfect? Is that all that's needed, is for someone to say, hey, I thought I needed to shoot him to protect myself, and then you always get the voluntary manslaughter?
I'd say it's up to a juror to determine whether he had an honest and sincere belief, not for the trial court. That is a factual question.
So all someone has to do is assert that I saw his hand next to here, and that meant something to me, so I can shoot him 11 times, and you get a voluntary manslaughter instruction.
Well, you have to consider this. I'm sorry, I didn't mean to interrupt you.
No, that's fine. Go ahead.
Okay. You have to consider the circumstances under which he makes this claim. They had just had a hostile encounter, a fight.
Understand? And Mr. Byer was restrained by a rather large man. The record indicates 6'8" and 400 pounds.
345. But there's evidence to which disputes that at the time of the shooting. There's witnesses that there is a claim that at the time of the shooting, Mr. Byer was restrained against a wall by this, I believe his name was Mitch McDonald,
Right.
weighing 6'8", 325 pounds, and therefore the victim was not in a position to threaten Mr. Qualls. Well, again, that's a factual question. It's
Refuted in some respects to the fact that there were 11 shots that entered the victim's body.
and he didn't have a scratch.
Right.
And that's the physical evidence, I would say, disputes that. But be that as it may. But to answer your question, Mr. Justice, is that whether I think the question is, well, then if what is an honest belief? What is the definition of an honest belief? And certainly the jury can consider. The jury is free to dismiss it. The jury does not have to accept it.
But my question is just by asserting, I saw this person over here, and he was, let's say, wearing a particular item of clothing. I was threatened by that. In my view, that's something that could lead me to believe that I'm in imminent danger and I'm going to shoot that person. Is that enough to get? I mean, is any declaration made by someone enough to get to a jury?
There has to be.
I mean, what role does the trial court have in saying no? There's no evidence of that, or yes, there is, to support the belief?
Well, I think the trial court would be obliged to determine whether there would be any basis for a person to believe that, any factual basis or evidentiary basis for for any person to come to that conclusion. If there was if the defendant made some kind of claim, he shot the person because he thought he was a space alien, well, that would be an extreme case.
Well, you're agreeing that the trial judge acts as a gatekeeper in these circumstances to make certain that the claim of subjective belief is not so unsupported or out in left field as to take it away from the jury. That gatekeeping function does apply according to you. I think our question is, then what does the defendant need to show to get past that gatekeeping function? Is it simply enough to say, I thought he was going to shoot me, or is there something else that the defendant has to present to get over that first hurdle?
Right. Could I have 2 minutes instead of 3 minutes? If I see my time is about up here.
You may.
There would have to be some basis for the defendant to have that belief, I would say. Some evidence for the defendant to have that belief. If he said that the victim had threatened him or acted in a threatening manner to him. There would have to be some evidence that the victim was acting in a threatening manner to him for someone to have that belief. He can't have that belief out of thin air. You can't imagine that belief. There has to be, I agree, there has to be some basis for that belief. In this case, there was a basis for Mr. Qualls to have that belief that Mr. Breyer was about to shoot him.
And as I understand it, counsel, the evidence you're relying on to support that is that they had had this physical altercation.
Yes.
Your client then walked away. Then he heard his wife call his name, which suggested to him that
Something was
he
amiss.
needed to turn around, and it wasn't just an ordinary calling of the name. There was something serious perhaps about to happen. He turned around and then saw the victim with his hands in his waistband.
Right. In fact, he said his testimony, his hands in his waistband and pulled something out.
Okay.
But he said he admitted he didn't know whether it was a gun or not, but he did. And so there was some base evidence for Mr. Qualls' belief. Again, he saw the victim pull his hand out of his waist with some object. And as I've indicated, it's not uncommon. In fact, it's commonly known that people conceal and carry weapons in their waist. And I don't. So,
Can you respond specifically to Justice Rosen's suggestion that perhaps the fact that he shot him 11 times might have some bearing on whether or not this was a reasonable belief that he needed to defend himself?
Well, I'm not a firearms expert, but I understand this was a 9mm automatic, semi-automatic pistol. And there wasn't any, should have been. And if a gun is fired, I mean, you can fire numerous rounds in a 9mm in a matter of seconds. I mean, that's...
And was that the testimony that the 11 shots happened in a matter of moments?
The evidence is the whole incident from the time even McDonald was less than a minute. The whole incident, that includes the time he was walking away. So we're talking about a matter of seconds.
Is that clear from the video?
I don't know, Your Honor. I'll be honest with you. I looked at those videos, and I'll be honest with you, I had a hard time making out what was on these videos, to be honest with you. And that's why I didn't cite anything in my record, because I couldn't really see what was on them. And I'll just be truthful about that.
Thank you.
Counsel, before you sit down, let me ask if the court has any more questions.
Oh, I'm sorry.
Any further questions? I see none. Thank you.
Thank you.
Good morning. My name is Jason Geyer. I'm an assistant district attorney in Shawnee County, and I represent the appellee. As a matter of housekeeping, you'll see I'm not on the brief. I'm here pinch hitting today doing oral argument. If you need my bar number, it's 19842. I'm going to argue the voluntary manslaughter instruction and maybe touch upon the premeditation, but I think what Justice Rosen brought up really kind of gets to the point. What is necessary to get this instruction? What you have in this case and what the state would submit to you is that there was not an honest belief that deadly force was justified, number one. And number two, the court has no duty to instruct if the jury could not reasonably convict the defendant of the lesser included. And I think we have both of those situations here.
Okay, repeat that second point.
Okay. Generally speaking, a district court does not have a duty to instruct on a lesser included offense if the jury could not reasonably convict on that lesser included.
And why could they not have reasonably convicted here of voluntary manslaughter?
Because the only evidence would be, in the state's opinion, would be Mr. Qualls' testimony. And
isn't it's a two-part equation on self-defense. It's a subjective belief and whether that belief is objectively reasonable, subjective and objective. And we have someone testify. I saw his hand go to the belt or to the pants, and I thought he was going to shoot me, based in part on the fact that he just hit me in the face not too long before. And so I subjectively believed that I needed to defend myself. Why doesn't that fit that prong, even if we say that wasn't objectively reasonable?
Because I think if you look at all the other evidence presented,
Why do we look at the other evidence other than to determine whether it was reasonable?
What if the defendant just gets on the stand and says, I honestly believed this was about to happen? Hasn't the defendant met the standard?
No.
How will you dispute that then?
Because, and if I can talk specifically about this case, I understand the defendant said, I saw the victim reach for his waistband, and indeed they just did have a physical altercation. However, you'll look at when he was shot, the death blow, the shot was in the back. He was being restrained. I don't believe he was a bouncer, but by another large patron in the bar. He was being walked out of the bar before he turned around. His back was towards the rest of the bar. So while you do have Mr. Qualls' testimony, I mean, it's irrefutable that the death shot came from the back.
Was that the first shot, though?
I don't know. I don't know if that's...
And were the other shots all in the back?
There were several shots in the back. I believe the testimony of the coroner is that there were other shots that came essentially left to right. But if you look at the video, where the door is to the bar, the victim was pinned up against that very wall. So it's logical that Mr. Qualls turns around, he would shoot, and they would hit left to right.
Let me ask you, is it your position that I've looked at that video a ton of times, and you can see Qualls because he's got the striped shirt, blue and white shirt. But boy, trying to make out the victim, Mr. McDonald, I think it is just sort of a blur. And so, but is it your position that there's an angle on that video that would let us know, that would show us, for example, whether he was being restrained or was reaching for his belt? I mean, I didn't see it,
no.
But I'm asking you if you think it's there and I need to go back and look again.
And I've not watched it a ton of times, but no, I completely agree. I think you can see Mr. Qualls pretty clearly, but as far as Mr. McDonald and Mr. Byer or any sort of movement towards the waistband, I'm in agreement.
Okay, so if the video doesn't help us, then we've just got, I mean, really the only objective thing you've mentioned would be the pathology on the bullets and whether that tells us anything. But otherwise, we've just got the testimony of witnesses as to whether he was, which is disputed, as to whether he was being restrained or not being restrained or reaching. And amidst all that dispute, why doesn't that get the defendant his instruction and then make it a jury question as to who had the right facts?
Well,
that's really what I'm wrestling with.
Okay. And I'll agree it's probably a close question. However, I think simply going back to the fact he was shot in the back, there was no gun found, no object found. The fact that the bullets went left to right would mean he would have been facing away from the front door, which is where...
He being the victim.
The victim, I'm sorry. Well, actually, both the victim and Mr. Qualls. I encourage you all to go back and watch the video. I think that is all clearly refutes Mr. Qualls' testimony that he saw the victim.
But you've already told me you agree that it doesn't show the victim. I mean, that's just a big old blur in the back of the bar.
I agree.
And so all we've got is Mr. Qualls in a shirt, and you see a couple of gun flashes. And I mean,
you see a couple of gun flashes. You see him also, at least I saw him take a few steps forward. You see him leaning over a table, shooting. Again, there's someone going forward, someone reaching over a table, shooting. Is that self-defense, even imperfect self-defense?
Well, you might if you wanted to make sure you didn't get hurt. But let me move you on. Let's assume we find that the voluntary manslaughter instruction should have been given. Mm-hmm. I wasn't clear from either party's brief what you think the standard of review is on the harmless error.
And I'll be honest with you, Your Honor, I don't know.
So we get to pick one?
I'll leave that up to you, Justice Johnson.
Well, no,
Okay.
We're talking,
Yeah.
is this a constitutional issue? I mean, we know what the standards are.
Uh-huh.
It's where do we fit this circumstance into our standards that we've enunciated in State v. Ward? Is the fact that the defendant has a right to present a defense turn a refusal to give a lesser included that is part and parcel of that theory of defense, is that a constitutional violation? And if so, you have the burden of showing, convincing us beyond a reasonable doubt that it had no impact. Otherwise, you're in the real probability arena.
I guess I'll take the bait. I'm not going to say it's a constitutional issue. I don't want to say it's clearly it's not harmless error, but no, I don't think it rises to a constitutional error. And I'm sorry, I don't know if I can articulate that much more than that.
Well, I don't think we've decided that. That's we're wanting your input.
Yeah.
You have an opportunity to try to influence what this court decides.
Are there any other questions on the voluntary?
The only thing I
Okay.
would say is I don't know that you're making a skip rule. I think it might have been mentioned, but you would agree that you can have both a premeditated murder that fit within the imperfect self-defense voluntary manslaughter, because normally if you kill someone because you believe that you need to do so to defend yourself, it's sort of a premeditated murder, isn't it?
Yes, I would agree with that, and I don't believe it was actually specified as the skip rule in the brief. And I'm aware of a recent, I think it was from October, maybe the Plummer decision. It's not cited in our brief. The skip rule is not to be applied mechanically. I'm not here to argue against that.
So you would agree in this instance the fact that we don't convict of the second does not provide any kind of factual preclusion to voluntary, because you could have a premeditated that was an imperfect self-defense.
I would agree with that, but I would also like to state that I think the fact that the jury did not convict on the second certainly lends credence to the fact that they probably wouldn't have convicted.
And how do you get there? If they believe this was an intentional premeditated shooting, they would go with the first degree premeditated.
Correct.
But if they were also given the option to say it was a premeditated intentional killing because the defendant thought it was necessary to spare his own life, then they could have reached
True.
the same. But they weren't given that choice, so
That's
how
right.
can we say they wouldn't have taken that opportunity?
Well, Your Honor, I can't say that for certain, and maybe I opened up a can of worms there. But, It sounds good. I'm familiar with the skip rule. I'm not going to sit here and debate with you that your scenario certainly isn't a possibility. So I'll withdraw that argument.
Do you have any further presentation, counsel?
I would just like to quickly touch upon the premeditation, which is issue number 2 in the defendant's brief. Even if you look at the defendant's brief, he basically claims that it was an instantaneous killing, but taking them at his word, if you look at page 12, it even specifically says that Qualls had seconds to make a decision to fire that gun. Seconds is enough for premeditation. He shot 11 times. Each one of those required conscious thought. So I wanted to reiterate to this court that there was clearly premeditation, which was sufficient for the first-degree murder conviction. If there's no other questions, I will stand on the brief.
Any more questions? Thank you, counsel.
Thank you.
Counsel, you had reserved rebuttal time.
I'd like to address the evidence about the medical evidence in this case by the coroner. And I dispute what the learned counsel had interpreted the medical evidence to be. As I stated in my brief, the coroner's evidence showed, the coroner's testimony was that the victim was shot from left to right from an angle in his back, not at a 90-degree angle in his back, but at an angle in his back, going from left to right to the front, and particularly to the front, which one of the bullets lodged into the forearm of the victim. Again, that's an interpretation that can be made of the medical evidence. Others may have other interpretations of the medical evidence. A jury could come to that conclusion. I'm not going to debate one way or the other what the evidence was, but that could have been a conclusion of the jury of that medical evidence, which would be consistent with Mr. Qualls' testimony that the victim was approaching him in an angle, in the location, in an angle.
And didn't the coroner say he could not determine the order of shots? Did I read that?
Well, I didn't read that, Your Honor. Maybe I just picked what I thought was favorable to my case. I saw that, and I'll be honest with you.
It's easy for us to confuse cases when we read several, and I may be confusing cases.
I read through the evidence, and I only selected which I felt was supportive of Mr. Qualls' position. So I'll just be perfectly honest with you. I perhaps ignored any contrary evidence, if there is any. So that being the case, and then again, I wanted to go back to the issue whether this was harmless, or was it a harmless error? Well, clearly it was a harmless error. It was not. It was clearly not harmless. In fact, as I've stated, and the case law states, a defendant has a constitutional right to have his theory of the case presented to the jury, which would include if his theory for a lesser included defense, if there is evidence to support that. And so to deny a defendant that right, that instruction, where there is evidence to support that instruction, is a violation of its constitutional rights, and therefore is a harmless error. It's harmful error, and it's not harmless. Thank you, unless there's any questions.
Any more questions of counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes this morning's docket. The court is now in recess until 9 o'clock tomorrow morning.